I am President Kent Oliver with a message of thanks to the members of the Freedom to Read Foundation for your support of our mission. We are pleased to provide you this video update regarding some of the legal cases FTRF has been involved with recently. Our esteemed General Counsel, Theresa Chmara, will provide you background and insight into these cases that we were able to participate in thanks to your support. Our commitment to our mission is stronger than ever. That mission is to protect and defend your freedom to access information, and in particular, to strengthen First Amendment and privacy rights of readers and library users. If you are not a member of the Foundation, we hope you will consider joining. For those who are, my sincere thanks for your continued support. Thank you.
Hello, my name is Theresa Chmara, and I'm the General Counsel for the Freedom to Read Foundation. And I'm here today to provide an update for members on different litigation matters in which FTRF has been involved over the course of the last few months. This is the Midwinter 2012 update. Just by way of background, Freedom to Read Foundation gets involved in litigation matters and cases in three different ways. Sometimes FTRF joins as a plaintiff, in which it's alleging, along with other groups, usually from the Media Coalition, that a particular statute is directly harming its members. In that case, FTRF joins the case as a plaintiff for the litigation. Another way that FTRF often joins a litigation is as an amicus. An amicus brief is filed generally at an appellate level, either a federal circuit court, a state Supreme Court, or the U.S. Supreme Court, where a party or a group of parties would like to provide the court with a different perspective. While there might not be direct harm with the particular statute at issue, FTRF, through the amicus, is able to provide the court with an idea of how that type of restriction on intellectual freedom could impact these groups later down the road, or a different perspective on how intellectual freedom issues are being impacted through the particular statute. A third possible way that FTRF might be involved in litigation is not as a party, either an amicus or a plaintiff, but providing some sort of expert assistance, perhaps background information, or having a librarian or a member of FTRF serve as an expert witness in the litigation in some way. There are a number of cases that FTRF is currently involved in. One type of case has been called a Mini-CDA case. FTRF has been a plaintiff in a number of these cases filed throughout the country. Currently, there are two, one in Alaska and one in Utah, that are pending. FTRF has been a plaintiff, and in these cases, the state enacts a statute which expands its harmful to minors statute usually to include the internet, and may also change some of those terms and restrictions that apply in the harmful to minors statute. In general, the presumption is that speech is protected, but there are certain categories of speech that are not protected by the First Amendment, including obscenity, child pornography, and material that is harmful to minors. But the test that the Supreme Court has applied to determine, or has asked lower courts to use to determine whether speech is considered obscene or harmful to minors, involves a look at community standards and a look to see whether the material is valuable as a whole. When the states have expanded their harmful to minors statutes to apply to content that is published on the internet, it creates a lot of ambiguity for those who are placing content on the internet. If the statute only applies to content distributed, for example, in a particular community, the person doing the distribution has an idea of whether in that community that material might be considered obscene or harmful to minors. Although, again, it isn't so until a court finds it to be so. However, on the internet, once a speaker in one state, for example in Alaska, places the content on the internet, or someone outside of Alaska places the content on the internet, it can be accessed by anyone around the world. When states have enacted or expanded these harmful to minor statutes to include content placed on the internet, the challenges that have been filed have been twofold. First, on First Amendment grounds, arguing in some cases that the terms are vague, or in all cases that the content that someone places in one state on the internet, they have no way of knowing who will access it, whether it's a minor or an adult, and that therefore by restricting them to only speech that would be fit for minors, it places a chill on speech. The second part of the challenge has been a Commerce Clause challenge. The Commerce Clause of the Constitution prohibits a state from legislating outside its borders. Thus, when a state expands its harmful to minors statute for content on the internet, which might then subject someone who lives out of state to a prosecution in that state, the allegation has been that it violates the Commerce Clause. And these challenges have been successful both on First Amendment and Commerce Clause grounds around the country. The two current cases in which Freedom to Read Foundation has been a plaintiff are in Alaska and Utah, as I mentioned before. In the Alaska case, the federal district court has held that the statute is unconstitutional and held specifically that, quote, the government may not reduce the adult population to only what is fit for children, end quote. And the reason for the court's finding is that the court held that technologically it was impossible for content providers who are placing material on the content to know whether a minor in Alaska would be able to access that content. For that reason, it was unconstitutional. Since no appeal was filed by the state government, that case is at an end at this point. The second case is in Utah. Again, Freedom to Read Foundation is a plaintiff in this case. That statute also expanded the harmful to minors statute to the internet. It additionally had some other requirements, specifically that if someone wanted to avoid prosecution under this statute, they could label their material as harmful to minors, and that would provide them for a defense down the road. But clearly, that defense could only be applied once a case had been filed, an actual criminal case against the speaker, and therefore it would chill speech because speakers would not want to be brought into court where they would be providing that defense. Nor do most people want to label their speech as harmful to minors when they're not sure how one community or another might view that speech. So that challenge is pending, and there are now motions that have been filed by both the plaintiffs and by the government, and the court is considering those motions, and we will be expecting a resolution on those motions sometime soon. The other category of cases in which Freedom to Read Foundation has been involved are actual library internet filtering cases. So whereas the Mini-CDA cases that I've been discussing pertain to a speaker placing content on the internet, in this case, the cases involve the right to receive information at a library. When there is a restriction placed on either a speaker's ability to place content somewhere or distribute content or to speak, or whether it's a restriction on the right to receive information, the government has to be able to show that it's a three-part test, that they have a compelling interest for the restriction, that the restriction is narrowly tailored to meet that interest, and finally that there are no less restrictive alternatives. And these are the tests that will be applied in these library internet filtering cases. The three cases that are pending right now, one is in Bradburn, is called the Bradburn case in Washington State, and this is a challenge to a public library's internet filtering scheme that they use, and essentially alleges that the public library would not disable the filters for adults or unblock a specific site, if the library determined that it wouldn't be appropriate for minors to see it. And the second case is in Missouri, and this is a challenge to a school library filtering scheme. In this case, the lawsuit alleges that sites supporting LGBT rights have been blocked, while websites that condemn LGBT rights are not blocked. So this is a challenge on viewpoint discrimination, challenging the filtering system, and again, it's in a school library. The third library filtering suit that's pending right now is also in Missouri and challenges the internet filtering in a public library. In that case, on the ground that sites that support minority religions, such as Wicca, are blocked, while sites that have a Christian viewpoint are not blocked. So again, it's a viewpoint discrimination challenge, but this time in a public library. Freedom to Read Foundation is not involved as a plaintiff in any of these cases. All these cases are at the trial level. In fact, the 2 Missouri cases have only just been filed in the last couple of months, so they haven't progressed very far. But Freedom to Read Foundation is monitoring all 3 cases at this point. Some background for those cases goes back to, of course, the SEPA case. In SEPA, which is a federal statute, requires libraries that receive certain funding to block access with filters to only visual images that are obscene, harmful to minors, or child pornography. It's plainly clear that filters block much more than that, and that they can't be geared specifically to block only that, or only those visual images. And that's at the crux of what the challenges are in these library internet filtering cases. In the ALA SEPA case, the Supreme Court did uphold the SEPA statute on a facial challenge. And a facial challenge, when somebody challenges a statute on facial grounds, the allegation is that it can never be applied in a constitutional manner. An as-applied challenge says it's not being applied constitutionally to me. That's why I'm filing the lawsuit. And in the SEPA case, the Supreme Court upheld the challenge because the Solicitor General had stated in the oral argument that libraries could disable filters for adults with no questions asked. Therefore, libraries would not have to subject patrons to providing bona fide reasons for why they wanted access, despite the language that was in the statute. On that basis, the Supreme Court upheld the statute, but the justices made clear in various opinions that were filed that an applied challenge might be forthcoming if, for example, libraries either didn't disable for adults, or there was an additional burden that was placed on adults seeking either a filter to be disabled or sites to be unblocked. And these are the 3 cases and the issues that are coming up now. There are applied challenges in Washington State and in the 2 cases in Missouri, in which the courts will now determine whether the SEPA statute is being applied unconstitutionally to those particular plaintiffs. Those cases, again, may take some time. The Bradburn case has some motions pending, but the other 2 cases are just at the very beginning. But Freedom to Read Foundation will continue to monitor all these cases and provide members with updates on their status. As I mentioned at the beginning, Freedom to Read Foundation also is often involved as an amicus, and in the last few months has joined several amicus briefs. The first is an amicus brief in a case that challenges the Stolen Valor Act. The Stolen Valor Act is a federal statute that criminalizes statements about receiving military honors. Mr. Alvarez was convicted for claiming falsely in an election bid in California that he had received the Congressional Medal of Honor. In fact, he had never received the Medal of Honor, and further, had never even served in the military. And when this information had come out, he was also prosecuted for violating the Stolen Valor Act, which is a criminal statute. The district court rejected his First Amendment arguments. He had argued that he had a First Amendment right to even make false statements, even if he knew that they were false. But he decided he would plead guilty, but wanted to maintain the ability to appeal on the First Amendment claim. And he did. And the Ninth Circuit at that point reversed the finding of the district court and found that, in fact, Mr. Alvarez had a First Amendment right in that case, and that the Stolen Valor Act was unconstitutional. Recently, a 10th Circuit case found the opposite, found that the Stolen Valor Act is constitutional. The Ninth Circuit case that Mr. Alvarez was involved with there was a petition filed to the U.S. Supreme Court, and the U.S. Supreme Court accepted that petition and is going to resolve this issue this term. Freedom to Read Foundation joined an amicus brief, joined by other groups as well, arguing that the Stolen Valor Act is unconstitutional and that there is a presumption that the First Amendment applies unless there is some historical exception, such as those that I mentioned earlier, where there are categories of speech like obscenity that are just not protected by the First Amendment, or if the government can make a strong showing that the presumption protecting intellectual freedom should not apply in that case, which the brief argued they had not done so in this case. That case will be argued on February 22nd, 2012, and it is expected that the Supreme Court will rule on that by the end of its term, which will be the end of June. FTRF has also been involved in another amicus brief that was filed with the state Supreme Court in Michigan, or a request for review, actually, that was filed with the Michigan State Supreme Court. A Michigan statute requires that anyone who has been convicted of a crime is prohibited from writing about that crime or their thoughts or reflections about their conviction unless the monies that they receive from that publication are placed in escrow and provided to the court for restitution. Additionally, the Michigan statute requires the publisher of such a book or memoir or writing the publisher is obligated to place that money in escrow without paying it out to the author. This is called the Son of Sam law, which in the past the Supreme Court held was unconstitutional because it didn't simply require restitution, but it pinpointed speech for restitution, and only speech. And the amicus brief, the Freedom to Read Foundation, has joined in this case, similarly argues that it isn't the restitution or collection of restitution that's unconstitutional, but that the restitution should be collected from any money received by someone who is convicted if they owe restitution. But requiring that restitution be gained only from speech and publications makes it unconstitutional. And additionally, that the requirements and the onus placed on the publisher makes this Michigan statute unconstitutional. That case is currently, the request is for review by the Michigan State Supreme Court, and the amicus brief that Freedom to Read Foundation has joined requests the Michigan Supreme Court to review whether this statute is unconstitutional. Another case with which FTRF has been involved relates to the Federal Communications Commission's imposition of fines on indecency and fleeting expletives. During the Bush administration, the FCC changed its policy on when it imposed fines on broadcasters. At that time, the FCC began to impose more fines more often, and there was less certainty about when a broadcaster could be fined. FTRF had joined a petition for reconsideration that was filed by a number of groups asking the FCC to review its policies on imposing these types of fines and to provide more guidance to broadcasters. The FCC, however, doesn't have to follow a specific timeline for reviewing those petitions for reconsideration, and the petition that was filed by FTRF was never reviewed. However, a similar petition had been filed by Fox Broadcasting and also by other broadcasters, and that was reviewed. The FCC denied the petition for reconsideration, which allowed the broadcasters then to appeal that decision to the Second Circuit Court of Appeals, and ultimately that case went to the Supreme Court. It's been to the Supreme Court in two rounds, one on an Administrative Procedure Act challenge, and then secondly on a First Amendment challenge. Currently, the Supreme Court is hearing the case again. The Second Circuit has found that the FCC policy is unconstitutional, mainly because it doesn't provide broadcasters with enough certainty as to when speech might be fined. And because broadcasts are generally provided live, a broadcaster may not have control over something like the Golden Globes or another live broadcast, and a speaker might utter an expletive that then the broadcaster is fined for that without having known what would be prohibited. The FTRF has been monitoring this case because of its petition for reconsideration, and the resolution in this case will also resolve the issues raised in that petition for reconsideration. The argument was held in January of 2012 and is currently pending, and again we expect that the Supreme Court will decide this matter by the end of its term in June. One of the issues that had come up at the argument was the difference between broadcast versus cable, and the unfairness that the FCC's jurisdiction only applies to broadcast and not to cable, and therefore broadcasters face more fines than cable companies. Cable companies wouldn't face any from the FCC. During the oral argument, the court certainly listened to those arguments about that, and one of the things that we expect the case will, or the opinion will, discuss is also this difference between broadcast and cable, and then finally whether particularly the policy violates the Constitution. That brings me to the end of the update, and these updates will be provided again in June at the annual conference. Thank you.